We will now come to the final relief that we will discuss in the nature of permanent relief, and this is the relief of delivery up. Now, once a plaintiff files a suit, they get the permanent relief of an injunction. They also get a permanent relief of, say, damages. What happens to the defendant's inventory? What happens to the stock that the defendant has stored with respect to the infringing trademark? In that case, it's the relief of delivery up that the plaintiff would like to enforce. Delivery up is when the court would direct the defendant to either hand over the infringing products, which would include advertisements, packaging materials, other paraphernalia that the defendant would have in its possession, to either the court or the plaintiffs. Now, what happens after delivery up takes place? In most cases, the infringing goods are destroyed under court supervision. But in a very interesting case before the Delhi High Court of Luxottica versus Muni, the defendant agreed to donate several hundred pieces of unbranded sunglasses to a blind school which were earlier infringing. We will now talk about interim reliefs that a plaintiff may claim in a trademark suit. Why do we need to consider interim reliefs when we've already discussed permanent reliefs? As you may know, once a lawsuit is filed, it has to go through the entire process of adjudication, including trial, before judgment in the suit is pronounced. This may take a few years depending on the jurisdiction in which the suit is filed. Since the judgment in a suit takes at least a few years, plaintiffs would like to have some relief that would protect their interests during the pendency of the suit. Hence, interim reliefs are sought. Now, we will discuss at least 4 kinds of interim reliefs that also find mention in section 135 of the Trademarks Act. Let's go back to section 135 of the Trademarks Act. You would recall we spoke about ex parte injunctions or any interlocutory order for discovery of documents, preservation of infringing goods, documents or other evidence which are related to the subject matter of the suit, restraining the defendant from disposing of or dealing with his assets in a manner which may adversely affect the plaintiff's ability to recover damages, costs or other pecuniary remedies which may be finally awarded to the plaintiff. We will now discuss each of these interim reliefs in detail. We will start with interim injunctions. What normally happens in a court is, once a lawsuit is filed, plaintiffs try to seek ex parte injunctions on the very date the lawsuit is first listed. These injunctions are called ex parte because they are sought and granted in the absence of the other party, when the defendant is absent before the court. For grant of ex parte injunctions, the standards set are usually very high, and these injunctions can be easily set aside under Order 39 Rule 4 if the plaintiff has concealed or misrepresented in any manner before the court. For grant of interim injunctions, the Supreme Court has laid down at least 3 factors that must be considered. First is the factor of a prima facie case. Second is the factor of irreparable harm and injury to the plaintiff. And the last factor is balance of convenience. We will first talk about prima facie case. By prima facie case, it is meant that the plaintiff has to establish at the interlocutory stage that it has a good case on merits. Now, this may be proved by relying on documents such as plaintiff's trademark registrations, documents showing long use of the trademark by the plaintiff, court orders recognizing and enforcing the plaintiff's rights, and also documents to show the infringing activities of the defendant. Once a party is able to establish prima facie case, it has to also satisfy the other 2 conditions. In the case of mandatory injunctions as opposed to prohibitory injunctions, the standard is of a strong prima facie case as opposed to a prima facie case. We will now talk about the second requirement, which is irreparable harm and injury. the plaintiff has to show to the court that the absence of an injunction will cause irreparable harm to the plaintiff, which may not be compensated by way of damages. In trademark cases, this is usually done by showing harm to the reputation and other intangible assets of the plaintiff. The last factor is the balance of convenience, which is actually a weighing scale by which the court determines the impact of the absence of injunction on the plaintiff on one hand and the impact of an injunction on the defendant on the other hand. And once it weighs the two factors and concludes whoever the balance of convenience is in favor of, this factor is determined accordingly. The second interim relief that we will talk of today are called antenpillar orders. Such orders also find mention in section 135 of the Trademarks Act as orders that help preserve evidence. What happens when a suit is filed? The defendant is made aware of the suit by the court. The defendant then has the option of actually destroying the evidence that may put it in jeopardy. Therefore, to avoid a situation where the defendant would actually destroy the infringing products, such orders are passed. These orders derive their name from an old English case called the antenpillar case. Under the Indian statute, the Code of Civil Procedure under Order 26 provides for mechanisms by which a local commissioner may be appointed to visit the defendant's premises and inspect what goods or services the defendant is offering there. In practice, a local commissioner is appointed who visits the defendant's premises and makes a noting of everything that is present at the defendant's compound. Once such noting is made, the local commissioner is usually empowered to take photographs, to record proceedings in other ways as well. Practically, once the local commissioner makes his report, the goods are handed back to the defendant on superdari, which means that the defendant cannot dispose of those goods and is simply a custodian of the goods that were seized by the local commissioner. The defendant is duty bound to produce those goods as and when directed by the court. We will now talk of the third interim relief of mariva injunctions. Again, the name is derived from an old case. Mariva injunctions also find mention in section 135 of the Trademarks Act as injunctions that are directed towards freezing the defendant's assets. In a recent case of World Wrestling Entertainment versus Vinayak Sondhi, the Delhi High Court froze the defendant's bank accounts. In this case, the defendant was operating an online portal through which it was selling infringing WWE merchandise. The last interim relief that we will talk of today are called discovery orders, which also find mention in section 135 of the Trademarks Act. Now, while discovery is accepted practice in all civil suits, there is a special kind of discovery process that is being recognized in intellectual property matters. These are called the Norwick Pharmacal orders. What is unique about Norwick Pharmacal orders? Now, these orders are especially helpful when information that would help the plaintiff establish infringement are not within its reach. For example, records of the customs. We have now concluded the section on civil remedies.